waiting for the live stream. Makes sense. Stuck. It is loading. It's very slow load. It's a slow load. Yeah. You've heard of the slow food movement? This is just slow in the load. Yeah. Well, you said Attorney Shipsey is gone for a while. Yeah. Hello.
Jan, it's actually streaming.
It's streaming?
Yes.
Okay. Okay, I'll start with the introduction. Good afternoon, Chair Holova, Vice Chair Lilac, commissioners, invited guests, members of the public, and staff. Thank you for joining us for this December 18th virtual special meeting and work session. My name is Jan Guerrero, and I'll review a few things to note, including best practices for participation. Recordings of the commission's meetings are available on YouTube. This meeting is open to the public, however, only invited testimony for agenda item 3, Clackamas County request to appeal a land use decision will be accepted. Again, we thank you for being with us today. Chair Holova, the meeting is yours.
Thank you. I want to call this meeting to order. Jan, could you please do the roll call?
Commissioner Warren.
Here.
Commissioner Boyer.
Virtually present.
Commissioner Lasso.
Good afternoon, present by video.
Commissioner Thompson.
I'm in the room, present.
Vice Chair Lilac.
Here.
Chair Holova.
I'm here virtually. Okay. This hybrid meeting, I'm like, is that everybody? And so now we're going to have some members of our commission read out loud our land acknowledgement. We'll first have Vice Chair Lilac and then go on to Commissioner Lazo.
Thank you, Chair. Are we going to post it online or shall I just read it from my script I have here? I can, whichever.
I think you can read from the script, and if they have it to post, they'll do that.
Okay. Indigenous tribes and bands have been with the lands that we inhabit today throughout Oregon and the Northwest since time immemorial and continue to be a vibrant part of Oregon today. We would like to express our respect to the first peoples of this land, the 9 federally recognized tribes of Oregon: Burns Paiute Tribe, Confederated Tribes of Coos, Lower Umpqua, Siuslaw Indians, Confederated Tribes of Grand Ronde, Confederated Tribes of Celeste Indians, Confederated Tribes of the Umatilla Indian Reservation, Confederated Tribes of the Warm Springs Reservation, Coquel Indian Tribe, Cow Creek Band of the Umpqua Tribe of Indians, and the Klamath Tribes.
It's important that we recognize and honor the ongoing legal and spiritual relationship between the land, plants, animals, and people indigenous to the place we now call Oregon. The interconnectedness of the people, the land, and the natural environment cannot be overstated. The health of one is necessary for the health of all. We recognize the pre-existing and continued sovereignty of the 9 federally recognized tribes who have ties to this place, and thank them for continuing to share their traditional ecological knowledge and perspective on how we might care for one another and the land so it can take care of us. We commit to engaging in a respectful and successful partnership as stewards of these lands, and as we are obliged by state law and policy, we will uphold government-to-government relations to advance strong governance outcomes supportive of tribal self-determination and sovereignty.
Thank you. And so we're going to begin the public portion of the meeting, which is agenda item number 3, which is the request to appeal Clackamas County land use decision with Kelly Reed from Portland Metro Regional, who's a Portland Metro Regional representative. Thank you, Kelly, for joining us.
Thank you, Chair Halova. Good afternoon, Chair Halova, members of the commission. My name is Kelly Reed. I'm regional representative for the eastern half of the Portland metro area. And I believe Jan would like me to present on my end, so I'm going to share my screen with you.
Yes, and I'm sorry, Chair, Vice Chair, Commissioners, I just wanted to let you know that I'm going to start recording the meeting.
Okay.
Thank you,
Can
Kelly.
everyone see my screen?
Yes, thank you.
Thank you, Chair. So the reason I'm here today is for agenda item number 3, the request to proceed with an appeal. Earlier this year, Clackamas County approved a zone change application. The department participated in the process by submitting comments before the county's public hearing. After the county issued their final decision, the department filed a notice of intent to appeal that was on November 21st. So I'm here today to request direction from the commission to proceed or not to proceed with the appeal pursuant to the appeal factors that are in Division 1 that I will cover later. So before I start here, I do want to acknowledge that we received written testimony from both the county and the applicant, and the commissioners received that testimony. The applicant also plans to testify today following the staff report, and Clackamas County, I believe, is not planning to provide testimony to you this afternoon. So this decision made by the county was a quasi-judicial zone change to upzone land within an area of rural residential designation in Clackamas County. The county has a 2-map system. The comprehensive plan map has 1 category for rural residential lands. The second map is the zoning map, which includes 3 zones within that rural residential category. Those are Farm Forest 10, which is a 10-acre minimum lot size zone, Rural Residential Farm Forest 5, which is a 5-acre minimum lot size, and then RA2, which is Rural Area Residential 2-acre minimum lot size. The proposal involves between 110 and 111 acres of land in Clackamas County. You can see the 2 parcels here in yellow in the map. Those are the 2 parcels that make up the total of 111 acres. These parcels were assigned rural residential and Farm Forest 10 zoning back in 1980 through an exception to goals 3 and 4. That exception in the zoning was acknowledged by DLCD back in 1980. So the proposal that we're talking about today would change the zone from Farm Forest 10 to RA2 to go from a 10-acre minimum lot size to a 2-acre minimum lot size. As a result, the property could then be subdivided into 55 2-acre lots. In its decision, the county did not require a Goal 14 exception, and that is the basis of the department's challenge. So as a reminder, since I just mentioned Goal 14 is our urbanization goal. This aims to limit urban uses to urban growth boundaries unless they are allowed outside an urban growth boundary through the goal exception. Goal exceptions are not easy. There's a high bar. Exceptions are the subject of rules in Division 4 and Division 14, and there are 2 pathways for a goal exception. There's a reasons exception, and there's an irrevocably committed exception. Since we're talking about goals, I will also note that since this is in a residential zone, it involves housing, you might think of Goal 10. Goal 10 is not really applicable here since this area is outside of an urban growth boundary. And Goal 10 is all about housing options and affordability and choices within urban areas. So the key administrative rule here is in Division 4, Section 40. The rule sets the standards for lot sizes in rural zones. Subsection 7 of that rule states that a Goal 14 exception is required for any change that allows a smaller lot size than what was in effect on October 4th of 2000. As you recall, this land was assigned the 10-acre zoning in 1980. That zoning was still in place in the year 2000, and thus the department contends that this rule says a Goal 14 exception would be required to allow the smaller 2-acre lot size. So I want to share some background of why that rule came to be, of how and why that rule came to be in 2000. There's a Supreme Court case that's important in this discussion, and this also will help explain why the department thinks it's imperative to proceed with this appeal. This Supreme Court case is from 1986. It mostly had to do with defining what is urban and what is rural. These terms were not defined in statute or rule. The court in 1986 declined to establish a bright line to distinguish urban or rural residential uses from urban residential uses, but it did say that generally 1 acre or smaller is urban and 10 acres or larger is rural, but that in between 1 and 10 acres, it depends and is handled on a case-by-case basis. So then between 1986 and 2000, a lot of counties are going through periodic review and kind of dealing with this legal decision and having to do this case-by-case analysis. Many parties, including the counties, property owners, were calling for LCDC to clarify, to provide some direction and establish a brighter line between urban and rural. So in 2000, LCDC adopted rules that address this topic. So here's what they decided. 2 main things. For new exception lands, so if a county was going to decide to create new exception lands, lot sizes are to be 10 or more acres. Unless you take a Goal 14 exception, then you can go less than 10 acres. For existing exception lands, LCDC was hearing from both sides, was hearing people say that that should be set at 10 acres as well. Other folks were saying that should be set lower at 1 acre or ½ acre. And LCDC struck a balance. They said if the zone was under 2 acres, the land must be brought up to at least 2 acres, minimum size. If the existing zoning was 2 acres or more, then the zoning can stay as is. But if you want to go smaller than what is there now, or what the zoning is now, that a Goal 14 exception would be required. So that's that subsection 7 of that rule. So DLCD has provided this Goal 14 exception guidance to counties for the last 23 years. Clackamas County did approve 2 similar zone changes without an exception in the last 18 months. And of course, you know, they didn't come to you. The department did provide comment on both of those cases to the county, asserting that they needed to take a Goal 14 exception. But we weren't successful in convincing the county of this. And so now that we see that the county is continuing to approve these applications, we feel that this is it's the right time to pursue an appeal. The county and the applicant, who you will hear from next, contend that 2007 LUBA decision provides an interpretation of this rule that supports their proposal. So in this case from 2007, LUBA found that Curry County was not required to take a Goal 14 exception to go from a 10-acre lot size to a 5-acre lot size within their existing rural residential zone. Clackamas County is relying on this case to support their decision here. The department contends that this 2007 decision applies to a very narrow set of circumstances and that it's not applicable to the Clackamas County situation. And we're not here to get into the merits of either of those arguments, but to decide whether to proceed with the appeal based on the appeal factors. But before I get into the appeal factors, I want to share a few maps to give you some additional context. The subject properties shown here are off of Highway 213, south of Oregon City and south of the metro urban growth boundary. Zoning is a mixture in the area. So there's farm forest 10-acre zone in the tan color, RRFF5, 5-acre in the brown color. And then just to give you a sense of scale, these, I hope you can see my cursor. These smaller lots here in these subdivisions are about 1/2 acre in size. And then up here in the tan color, these lots are about 2 acres. These subdivisions were mostly built in the 1960s and 1970s prior to land use planning program implementation in Clackamas County. This site is neither rural reserve, which is shown in green, or urban reserve, which is shown in blue. It is undesignated land outside of the metro urban growth boundary, and that growth boundary is shown in the red dashed line. And it's about 1 mile south of the urban growth boundary. And as I said earlier, this part of Clackamas County saw significant rural subdivision development in the 1960s and 1970s. Across from the site, you can see there's a private golf course. And then you can see the larger parcel of the site is kind of an open field, and then the smaller parcel is forested. The applicant included a conceptual subdivision layout in their application to Clackamas County. Now the subdivision isn't proposed yet. This is just a conceptual plan, and the subdivision would be a subsequent application to the county following a successful zone change. But the plans include an extension of a public water system, and each property would have its own septic system. And then last, here's an image from the site from Highway 213. The site includes a single family home, not shown here, a barn, and is used for various farming uses, including livestock grazing, which you can kind of see there in the distance. So in summary, this request is to proceed with an appeal of a decision to allow zone change in rural residential lands without a Goal 14 exception. The department contends the exception is required based on rules in Division 4. Clackamas County asserts that the 2007 Curry County LUBA case supports their decision, and a LUBA interpretation would tell us whether or not the language in that rule carries out the commission's intentions and does what we believe it does, and what we've been telling people for the last 20 years it does. So the appeal factors, the commission relies on the rules in Division 1, Section 230 in appeal decisions, with the ultimate question being whether one or more of the appeal factors in subsection 3 are met. I'll go through each of these appeal factors briefly. Factor A is whether the case will require interpretation of a statewide planning statute, goal, or rule. This is the major factor here. This case would provide for interpretation of the Division 4 rule about Goal 14 exceptions. And similarly, appeal factor B is also true here, that statewide planning law could be further clarified by LUBA through an appeal. And you know, this situation, you know, these types of zoning designations are present in counties all over the state. And so this is relevant statewide. The department doesn't think factors C and D are relevant here. Factor E, which is whether the case advances objectives of DLCD's strategic plan, is indirectly implicated to the extent that the rules in question support the objective to promote healthy and equitable communities by directing significant residential development to urban areas of the state. And finally, factor F speaks to whether there are better ways to accomplish the objective of the appeal. In this case, we think a LUBA interpretation is the next logical step. The county asserts in their letter to the commission that rulemaking to clarify the Division 4 rules is a better path. While the department agrees that rule clarifications may very well be needed, we think it makes sense first to have LUBA interpret the existing rule. So the director's recommendation is that the commission authorize staff to proceed with the appeal. And you have two possible motions here on your screen. The proposed motion on the left would allow us to proceed, and the alternative on the right would direct us not to proceed with the appeal. Thank you. And Chair Holova, I welcome your questions after the applicant's testimony, and I'll turn it back over to you. I believe the next item is the applicant's testimony. Thank you.
Thank you. Thank you, Kelly. And I just wanted to outline for everybody present what their next steps here on the agenda. So we're going to hear from Garrett Stevenson next, the attorney for the petitioner. And then we're going to hear from Caleb Hugel, attorney for Clackamas County. And then we're going to have time to ask our questions of all of the above, I presume. And then we're going to have time to deliberate and vote. So next up, Garrett Stevenson, attorney for the petitioner.
Thank you, Chair Holova. Can you hear me okay? Great. Thank you again, Chair and members of the Commission. My name is Garrett Stevenson. I'm legal counsel for the applicant in this case. And full disclosure, I'm also on one of your racks. So, if you want to say something bad about me, you should probably do it after I'm off of the Zoom here. But it's nice to see all of you. And I appreciate Kelly's testimony, kind of giving you guys the lay of the land, although you'll probably hear how I disagree with some of what she said. This case, at least as far as myself and the county is concerned and the applicant, is a straightforward application of the Clackamas County Rural Plan element that's been in place since 1980. And as Kelly mentioned, this policy allows the county to apply either a 10 acre, 5 acre, or 2 acre minimum lot zone to any area identified as rural on the comprehensive plan. And this particular property has been identified as rural on the comprehensive plan since the county adopted its original comprehensive plan post Senate Bill 100. I wanted to, before jumping into the state administrative rule component of the discussion, give you guys just a recitation of what this policy says, because it's important to keep in mind that LCDC has been confronted with this particular policy, as I understand it, on 2 prior occasions, one in 1980, then one during a periodic review between 1986 and 2002. And the policy is as follows, and I also inserted it into my written testimony. But starting with 4MM5, this is in the Clackamas County Comprehensive Plan, existing large lots should be reduced to meet future rural housing needs prior to expanding the areas designated as rural. And to that end, the county adopted policies which dictates how it decides which one of these buckets it goes in, either the 10, 5, or 2 acre lot bucket. Policy 4MM.11.1 provides as follows: the RA2 zoning district shall be applied. So this is not this is not a volitional thing on the part of the county. It's saying if it meets these criteria, the RA2 zoning district shall be applied when all the following criteria are met. Parcels are generally 2 acres or smaller. The area is significantly affected by development. There are no natural hazards. The topography and the soils are suitable for the location of homes. A public or private community water system is available. And so I want to highlight that. It's something that I think Kelly was sort of holding against us, the idea that we are going to have public water, but it's something that this policy that the county adopted, that DLCD and LCDC has acknowledged, actually requires. The 5th item here is areas are in proximity or adjacent to an unincorporated community or incorporated city. And F is in areas adjacent to urban growth boundaries. RA2 zoning shall be limited to those areas in which virtually all existing lots are 2 acres or less. And in order to make that showing, we did a pretty sophisticated analysis about the average lot size within a quarter mile, half mile, and 1 mile of the site. And it wasn't even close. Something like 80% of the lots were smaller than 2 acres. So that was, I think it's important to understand that this is the rule that the county has had for a long time, and that up until really today, LCDC has never had a problem with, and at least on 2 occasions has affirmed. I do think that when we turn to the administrative rule, particularly OAR 660-004-0040 sub 7, I think that Kelly's summary of that rule is fine as far as it goes, but it leaves out some critical language. So I'm just going to read the rule. It says, subsection 7 says, after October 4th, 2000, a local government's requirement for minimum lot or parcel sizes in rural residential areas shall not be amended to allow a smaller minimum for any individual lot or parcel without taking exception to Goal 14. And so what it doesn't say is that any application of a zone that allows a smaller minimum lot size would require a Goal 14 exception. What it says is that a local government's requirements for minimum lot or parcel sizes in rural residential areas shall not be amended to allow a smaller minimum. And that's not what happened here. This is an application of an existing zone according to the straightforward reading of the county's acknowledged plan. And that turns us, of course, to this Curry County case, which was called Oregon Shores. Again, the problem with this appeal is that the county's plan had an existing plan, the county's plan had an existing policy that allows it to switch between these zones. That was never, that was never changed, and it was acknowledged. And again, the decision does not change the county's requirements for how it applies these zones in rural areas. So in the Oregon Shores case, the critical piece, and I'm going to go ahead and read it out to you, is that the opponent in that case argued that, well, you're going to be changing your code and you need to have a Goal 14 exception if you ever want to reduce lot sizes from 10 acres down to 5. And that rule, subsection 7, as we just read, does not make a distinction between 5 acres and 10 acres or 2 acres. It says anytime you're going to reduce it, you got to go through a Goal 14 exception, but only to new plan policies and zoning code amendments that have been adopted since then. And that's exactly what Luba said. And it said as follows: the county contends that petitioner's argument under the first assignment of error is an impermissible collateral attack on the unamended acknowledged comprehensive plan. And that's what they're saying. That's what we're saying. The plan is what it is. It has been acknowledged, and preventing us from using the plan as it has been acknowledged would be called a collateral attack on the plan. And it goes on to say, we set out the text of this section again as follows: after the effective date of this rule, a local government's requirements for minimum lot or parcel sizes in rural residential areas shall not be amended to allow a smaller minimum for any individual lot or parcel. And Luba went on to say, while the text of that section could be clearer, we believe it refers to an amendment to allow a smaller minimum lot size and does not refer to an existing acknowledged zoning ordinance that already allowed a reduction from a 10-acre minimum to a 5-acre minimum. And so what Luba was saying there is you have an acknowledged plan that allows you to move between different lot sizes in rural zones. Now, there is no question that if Clackamas County wanted to amend its rural plan policies, it would have to do something different here. But it hasn't amended those rural plan policies. This is a zone change. It is not a plan amendment. And so all we're doing is applying the land use regulations as they are in the code that has been acknowledged. And just like in Curry County had a plan and a code that allowed you, very similar to Clackamas County, to move between, in that case, it was 10 and 5 acres. In Clackamas County's case, it's 10, 5, and 2 acres. And what Luba said is these rules are new. That plan policy and those zoning code provisions have been acknowledged. And if and when somebody comes in to amend that code or plan, then we have to look at doing the Goal 14 exception, but we don't have to do it now because of the language of the rule. And that language, I want to be clear, it was stated in in subsection 6 back in 2007. Now it has been renumbered as subsection 7, but it's the same language. And that's why, you know, our position and the county's position is that this rule has been interpreted by LUBA conclusively. And the problem, I think, the problem that, as a practical matter, the county and we have is not only has this rule been interpreted, but people have relied on that interpretation to a great degree. Now, we understand that DLCD staff has guidance that may suggest otherwise, but when you are representing an applicant and if you're representing a county, you got to go with what LUBA is telling you. And LUBA has been very, very clear on this particular point. And so, you know, really to use this as an enforcement mechanism to get around what LUBA has already said about the rule, it really doesn't do the department or the county, and certainly not my client, any service. What it does is it would potentially kill this project, because as a practical matter, I'm not sure how you get a Goal 14 exception to go from what the county has found is a rural area to go to another rural area. But putting all that aside, you know, our belief is, you know, this is a long-standing LUBA opinion. We understand that DLCD staff disagrees with it. And that's why when I talked with county council, we both agreed that there's got to be some more productive way to get at this issue rather than going after a very, very specific project, especially right now when we're talking about home building. Now, staff has said Goal 10 doesn't matter in counties. I'm not sure whether I agree with that or not. But the fact of the matter is, this is not a comprehensive plan amendment. It does not dictate broad county policy, but what it does do is it allows for a specific land development project to move forward. And so what the county and I have both stated in our testimony is that when it comes to enforcement, there's two correct ways to do this here. Because again, the county is not going to make a decision that is inconsistent with LUBA's prior holding. So if LCDC wanted to initiate an enforcement procedure against the county to do something different here, perhaps that is one way to go. The other way to go would be, since the operative language of this particular provision has not changed, to engage in rulemaking, work with the county to decide how LCDC and the county want to see these areas develop. And to be clear, they will develop. These are not resource zones. They're going to develop with something. You can do 10-acre minimums, 5 or 2, but we think the appropriate way is not to punish an individual project, but to work with the county on a collaborative process where they can do something different here and to clarify the rule, which has not changed. So with that, I'm happy to answer any questions, but we've gone through the reasons according to the formula, the 5-factored formula, I believe it is, and I'd encourage you to look at that in our letter. But we certainly don't see this as the right way to do policymaking or enforcement. I think the county is willing to look at other ways, as are we, but we just don't think this is the right case. And frankly, we think that what this case will ultimately amount to is, you know, DLCD trying to have another bite at the apple when LUBA has been very clear what this rule means.
Thank you, Mr. Stevenson. I think we're going to move on to Caleb Hugel, attorney for Clackamas County. A 10-minute presentation.
And I'm sorry, Chair, to interrupt, but I don't believe Caleb's available.
Okay.
He did submit written testimony.
That's correct, Chair.
Okay. So I think now we're going to open it up to the commission questions, which I believe can be to both Kelly Reed and also to Garrett. Vice Chair Lilac.
Thank you, Chair. First of all, Garrett, thank you for serving on Iraq. We certainly appreciate that. I certainly appreciate that. My second comment is I didn't hear any comment from DLCD and didn't see anything in the staff report, unless I'm mistaken, about enforcement. I'm just hearing appeal to seek an interpretation. Now I have 3 questions, and I'll just get them all out there and then turn over the rest of my time. So the first one I heard Ms. Reed state about this being relevant statewide. Well, I'm just curious if there's no interpretive matter, then any county that has this plan designation and with multiple zones, they can automatically apply from one zone to the next, from like the 10-acre minimum to the 2-acre minimum. Is that what I'm understanding is just the direct is the direct application of this rule, and it doesn't require an interpretation. I want to make sure that I clearly understand that. That's piece number one. Piece two is, I heard you say that the goal of 14 exception would be difficult if it's required because it's going from rural to rural. I'm curious about that because it seems like, given the land use pattern around the area, given that it's not in the urban reserve or the rural reserve, is it really, would it really be that high of a bar? Generally, I get it. Goal 14 is, I mean, it's, any exception is extremely difficult. So I'm just curious about your perspective on that. And then my third question, as I read, and I'm sorry that the county's attorney isn't here, and I appreciate Ms. Reed's statement and your comments about the county agreeing with not wanting the DLCD to appeal this decision. However, I'm just curious in your response, in the letter that we have from the county's attorney, he specifically states, and I'm just going back to the appeal criteria factors, the county agrees with DLCD that this case will require interpretation of a statewide planning statute goal or rule specifically, and it's this one we're talking about. And in the very end of the same paragraph, the county agrees with DLCD that this case will serve to clarify state planning law. So I'm just curious about your response to that, because those are the very first two factors, the first two criteria that we use to evaluate this. So thank you a lot from me, but I'm just curious about your responses to those, and or of course, Ms. Reed's. Thank you.
So Chair Halava, it sounded like Nick's last question might have been for me since Caleb's not available. So I'd like the opportunity to answer it if it's okay.
Yeah, we can go in reverse. You might have to rephrase your first two ones also.
Well, it works even better for me because my memory is really good 30 seconds back, but maybe not 90 seconds. So I think, I can't necessarily speak for what was in Caleb's head when he stated that. I think if you look, my position and the applicant's position is very clear, and certainly as we're the ones that would be, the litigants on the other side of this, our position is clear. LUBA has directly interpreted this rule already. We have acted in conformance with LUBA's opinion. And so I think that the case is really about not so much what does the rule mean. LUBA's already said what it means. The question is, does it apply, does LUBA's interpretation apply to these circumstances? And that's what I put in here in my testimony, I believe. And as to whether it would have, I think the second one was, sorry, I think it was statewide import.
Yes, I just about the relevant statewide, and then the other
right. I think everybody's been making a lot of assumptions about how many counties have rules that operate in this way. I don't know the answer to that. All I know, Commissioner Lilac, is that Clackamas counties has rules very similar to the ones adopted in Curry County. Whether there's other counties that have the same issue, you may see similar applications come down the pike, you may not. I guess our frustration, though, is that the the county has put forth this particular plan policy, which I read at the beginning of my discussion, before LCDC on 2 separate occasions, and both times LCDC gave them a thumbs up. And that's both before and after this decision, or excuse me, both before and after these rules were established. And so again, I think that if LCDC's goal here is to just make it clear that anytime you rezone a property, even if it is based on a plan that allows it, that has been acknowledged, that they need to go through a Goal 14 exception, I think that's a rulemaking. I don't think that it is a site-specific LUBA case, because the rule doesn't say that. It just simply does not. LUBA found that it did not. Can LUBA change its mind? I suppose it could. And at that point, maybe LCDC has done rulemaking for a bargain, but I don't think either myself nor the county council want to do it that way. And that's why the county council explained in his testimony that they'd rather do this through a rulemaking.
Thank you.
Your first two questions, Vice Chair Lilac, do you want to repeat them? Because I felt like maybe those were for Kelly.
I think Mr. Stevenson responded just about the potential application statewide. He answered that, and then the only other one was just, and he answered the Goal 14 question. So I'm good. Yeah.
Okay.
If Kelly is interested in any responses, I certainly welcome it. But
yeah, I'm also interested in the decision to do one process over the other. So I mean, that's sort of what the heart of the conversation was right now.
Thanks for the question, Chair Halova, Vice Chair Lilac. I think first, regarding the difficulty, the high bar of the Goal 14 exception, when we wrote our comments to the county on this during their public hearing process, we didn't address whether we thought a Goal 14 exception would be successful if the applicant pursued it. So if this went to appeal, the appeal would only involve whether the Goal 14 exception rule is applicable, not whether a Goal 14 exception would be granted. So the other two zone change cases in Clackamas County last year and earlier this year, you know, when we looked at those, and you know, we objected to those, but didn't bring them to you as a potential appeal. And part of the reason for that was also that, you know, they were kind of surrounded by other smaller parcels, and it looked like a Goal 14 exception would be easier, or, you know, it was a little more clear that a Goal 14 exception might be successful in those cases anyway. And we thought in this particular example, because of the size of the parcel and the surrounding development pattern, that it's really not clear whether, you know, whether a Goal 14 exception would be successful here. I think that's not really what we're here to answer. And as far as rulemaking versus an appeal, you know, LUBA did say in their 2007 decision, I believe, something to the effect of, while the language of this rule could be clearer, you know, and this is the rule we're talking about now. So I think we know that it's not explicitly clear, and because that case we think was so narrowly applicable to Curry County and not necessarily beyond Curry County, that we think that a LUBA interpretation would add a lot of clarity here. And I'll also say Gordon Howard is present, and he might be able to speak better to some of these, some of the questions as well.
Commissioner Lazo.
Thank you, Chair. Thanks for being here, Garrett. Appreciate you appearing today, and also that you are on the RAC, and so appreciate you being involved in that work. I had a couple questions. I just want to make sure I clarified that you talked about two instances where LCDC had affirmed this process before, and I'm not sure are you referring to the two applications that Kelly also referred to, or are you talking about the acknowledgement of the comp plan by DLCD? I just want to make sure I'm understanding the instances you're talking about.
Commissioner Lazo, that's a very good question. And they're both dynamics are at play here. And so what I'm really, you know, and let me take the prior, I'll just say that when and I'm going to put my site specific applicant's attorney hat on here just to communicate to you guys kind of what the analysis is when we decide to do projects like this. So for this one, we were aware that there were two prior hearings officers' interpretations of this rule, exactly the same as ours. Yeah, different sites, but the rule interpretation was exactly the same. And so you know, when I looked at this case, I spoke with the county staff. They said, this is what we've said. And, you know, DLCD has never challenged us on this. And so I said, all right, it makes sense. Let's move forward. And those are the two quasi judicial decisions that are the same as this one, where they went from a 10-acre zone down to a smaller one. Now, I think what is more relevant from a legal standpoint is the fact that, as I read in the beginning of my talk, there has been a clear policy that this county has had that was part of its original plan and then was part of its periodic review. And that periodic review, as I understand it from the county, was specifically to deal with the original Oregon Supreme Court Curry County case. And they looked at that policy again, which says, here's where you put in 2-acre zones. And they said, yeah, that's great. So it's very, very, I think, troublesome for, the public and home builders and developers and whomever to have that history of, essentially acceptance of what Clackamas County has been doing, and then apply for an application, make an application that's consistent with what has come before, and then boom, DLCD wants to appeal that decision. And I respectfully disagree with Kelly on the question about whether or not that Curry County case was specific to Curry County, for the same reason that she is saying we need an interpretation of this rule which would echo statewide. That's exactly what you had in Curry County. They were specifically construing that language. I don't know of any reason why that case in Curry County that was interpreting and applying that language would not apply outside of Curry County. And certainly that is exactly what DLCD staff is asking for here. But again, because LUBA specifically ruled on this particular rule and said it could be clearer, I think that's far more of an invitation for a rulemaking than it is to subvert the reasonable expectations of property owners when they go forward to do development.
Can I ask, I'll come to you, Commissioner Lazo, but I just wanted to ask again almost the same question. The 2 cases that you're talking about that I presume are the ones in Clackamas County, Kelly, are those the same ones that you said that the department made an objection to?
Chair Halova, thanks for the question. Yes, we submitted a letter to the county for each one of those, contending that a Goal 14 exception should be taken.
Okay. Because Garrett, I think you were saying that the department gave a a thumbs up, sorry, on those, and then Kelly said that we wrote objection letters. So
no, the department gave a thumbs up on the periodic review. We knew going into this, we simply knew that these 2 others were approved, same as ours, and that DLCD didn't approve. I didn't want to imply that they supported them. They didn't, obviously, but I didn't have those records before us. I guess the point I was trying to make is that when we investigated the issue with the county, we had no reason to believe necessarily that we would end up in an adversarial position with DLCD because they had not actually taken any action. I see DLCD comments all the time. Some of them I agree with, some of them I don't, but they had not, the point being is that they had not taken enforcement actions against those 2 other projects. But again, I think that for us, the legal question of what is the applicable law, the acknowledgement process is far more relevant, at least in my mind.
It seems to be the point at which you disagree. Commissioner Lazo?
Thanks, Chair. Yeah, I had a couple other items I wanted to continue on, in part with Garrett, and then I think I also have a question for DLCD and probably best suited for Gordon to answer. But Garrett, I think if we stay with the Oregon Shores versus Curry County case and make the assumption that there are parallels to the Clackamas County case, I think there's a third leg to it that I'm a little curious about that is brought up in DLCD's letter. It's this the sense that we could move from a 10 to a 5, but Curry County was actually asking for a 2-acre minimum also, and I didn't read the actual ruling, but in the point that is made by DLCD, the DLCD letter, it sounds like LUBA had actually told the county that yes, you could add the third layer, that 2-acre minimum, but you would need to do it with a goal. It would require a goal exception, which actually would mirror what you all are looking at here in a very different way. But it's just a third leg that's missing from your all.
Sure. So there's two pieces, there's actually 4 pieces to that opinion. One of them dealt with the 2 acre, one of them dealt with the subsection 6 language with what we're dealing with here. As it regards Curry County's plan that had already been acknowledged, okay? What we're talking about here, and I'll use sort of a crass way to describe it. What we're talking about here at the end of the day is grandfathering. The rule specifically grandfathers existing plan policies that allow you to change to lower lots, to smaller lot sizes. And at the time that that rule came out, Curry County had a plan that allowed you to choose between, to essentially zone change between 10 and 5 acres. Okay, that was on the books when the Division 40 rules came down. And what Luba said is that because it was on the books, not because it was 5 or 2 or 10, but because that plan had been acknowledged, those codes were in there, because those were on the books, we are not going to disturb the county's practice of moving between these different zone, these different lot areas. What Curry County didn't have on their books, which Clackamas County does have, is an allowance for 2 acres. And so in that Curry County case, they were actually trying to add an allowance to go down to 2 acres. Well, that's not what we're doing here. That allowance existed at the time of acknowledgement. And so what Luba was saying is that you're grandfathered in because you have an acknowledged plan that allows you to switch between these zones. The same exact circumstance is the case in Clackamas County. It just so happens that instead of just having 5 and 10, they have 2, 5, and 10.
And I don't know if it was asked for Gordon to speak on this.
Well, I have a different
Commissioner?
question for Gordon,
Okay.
Chair, if that's,
Yeah.
And actually what Garrett said is a lead into this, and I think it's probably not a great question, and I'm not sure there's a good way to answer it, but my question is around the acknowledgement of the comp plan. And, if we had a problem, if we have a problem with it now, did we have a problem with it at the time that the comp plan was acknowledged? My sense is also that I'm not sure that we can challenge every single thing that comes through every single comp plan. So has this always existed as a question? Is it the way it's being applied? Is it the way that's being applied to this particular rule, or because it's being applied now to certain applications? So what is there something that we could have or should have done at the time, at the acknowledgement of the comp plan, or has something changed to bring us to where we are today?
Yeah, Chair Alova, Commissioner Lazo. I believe perhaps the 2 different times that assertion that LCDC affirmed what Clackamas County had written, I believe the first time would have been at the initial adoption of the comprehensive plan about 1980, and the second time was at periodic review. I'm just looking through the files. I believe that periodic review would have occurred in the 1990s because by 1999, counties were no longer required to do periodic review by state law. So, I mean, the county did that with this, and I would point out that our rule was written in the year 2000. So our rule came after, I believe, the 2 times that LCDC through first the adoption of the comprehensive plan and then approval of a periodic review affirmed that the Clackamas County land use provisions were correct. And so I think that when they're saying that we twice did this, I think those are the 2 times that we're talking about. And my counter would be that those were both before LCDC adopted rules on this subject in 2000 to allay the longstanding controversy that was going on between 1986 and 2000 with all these counties around the state.
Thanks, Gordon.
For the record, just from what I understand, and again, I don't have the documents in front of me, but from what I understand from county staff, including the county council, is that periodic review was approved in 2002, so 2 years after these rules were written. And that's something that was pointed out in the hearings officer decision.
Yeah, I would have to, looking through the records, I'd have to defer to Mr. Stevenson and say I'm not sure exactly. It was certainly initiated in the 1990s and may not have been finished until 2002. We could get into all sorts of legal questions about when, what rules are affected when, but that's the approximate timeline that we're talking about.
Lucky for us, Gordon, we can all point back to the county because they're the ones who told me.
Okay.
Commissioner Warren, you had a question?
Yeah, thank you, Chair. So I think this is mostly a question. This is a question for staff, really. Is the question we're trying to get at LUBA's interpretation of what a action is to be amending to a smaller lot or to a smaller minimum for any individual lot or parcel? Is that what we're asking LUBA to opine on here? Because to me, when I read the rule, the county would have to be making a change to their law, which would be legislative. This decision seems to be quasi-judicial, so they didn't make any legislative amendments. So could you answer that for me, please? Like, are we looking at that specific question?
But yeah, Commissioner Warren, Chair Holova, we're looking at the question of how this particular rule provision is applied. And Clackamas County and Mr. Stevenson have one interpretation of that. And I think Mr. Stevenson's arguments are that the interpretation is so obvious that we shouldn't bring it up to LUBA because it's very clear. We at the department level disagree with that, and we've expressed that to Clackamas County. We believe that, I mean, I'm getting into the details of the difference between Curry County's zoning and plan provisions versus Clackamas County's zoning and plan provisions. I don't know would be productive at this point. I think that the question is, we need an interpretation of this because, like as Kelly said, we've been giving this advice to counties for over 20 years. And if we've been giving the wrong advice, we need to know that. And LUBA, as opposed to being told by Clackamas County, we're giving the wrong advice and saying, yes, we agree with you. What we're saying is let's let LUBA decide this at once and for all, perhaps.
Thank you.
Madam Chair, could Commissioner
Thompson?
Thank you. Well, it's clear that there's a difference in what's the correct legal interpretation. As we look at that, if we send this to LUBA, then who has to pay for that is the applicant, both in time and money. If we do a rulemaking process, because what we're looking for is clarification about what's the appropriate applicable law. I mean, if I'm incorrect in anything I say, somebody please tell me that. But who pays for it and what's a better process to clarify what's the applicable law? What's faster, what's less expensive, what's more effective in providing us good law with which to advise counties all over the state on how to make these decisions.
Yeah, Commissioner Thompson, Chair Holova, that's a very good question. I think that the answer would be that it would probably be more timely and more efficient to have LUBA clarify the law than for us to take this up in rulemaking. I can say that I reviewed at one point the rulemaking, the efforts that led up to the rulemaking in 2000. And Kelly pointed out that this was a very controversial rulemaking. It took several years. I personally at one point had to go through a file with several hundred pages of testimony to the commission on the subject statewide. I believe that, you know, as a practical matter, if you were to take this up as a new rulemaking, you would have a major item on your work program that would take a long period of time to resolve because it's a very controversial issue that we believed was resolved in 2000 with these rules. And, you know, I think my argument would be that going to LUBA would actually be, although more expensive for this applicant, yes, certainly, yes, but more efficient in terms of time to resolve this issue statewide.
So if it's okay, I'd like to weigh in at least on the applicant's perspective on the allocation of cost here. As you can tell, I'm not a fan of doing policy through LUBA appeals. And I think that, you know, in this instance, it is exceptionally expensive to go through this process with LUBA and with LCDC. And I just don't, I mean, just from an equity standpoint, I'm not sure how it's fair to necessarily single out one application, say, we are going to put our policy objectives on your back and you're going to have to carry this through the land use appellate process for us. And so I would really object to the sense that, well, yeah, it would be harder work for DLCD or LCDC to do it through a rulemaking, but it's okay because these guys, they'll have to pay their legal fees and then we'll get a decision. But the other thing that I think really is problematic with just throwing out the idea of rulemaking is because as I read this LUBA decision, that's exactly what they're asking LCDC to do. When they say the rule could be clearer, that's a signal to agencies that they ought to think about clarifying the rule. LUBA is not going to do that for you. And the other thing I would also caution is that if we're successful in our LUBA appeal, the department is going to be right back to where we started. And at that point, you will be looking at doing a rulemaking. And I have a relatively high degree of confidence that we will be successful, simply because, again, LUBA's already ruled on this. And so I do think that in policy making through going after not just, and somebody mentioned, I couldn't remember who it was, that this was not a plan amendment. I think that's very relevant. I mean, we are just applying the laws as they sit in the county's plan and in their code. We did not apply for a post-acknowledgement plan amendment. And there's a state statute that specifically says that when you're not doing a PAPA, you have to apply the code that is in the plan and the zoning code. And that's another reason why I think that this type of case, this is a quasi-judicial permit according to specific criteria. This is a bad way to do policy making. If it had been a post-acknowledgement plan amendment, a whole different set of rules apply there. So I would really, at least from my client's perspective, the idea that it would be hard work for the LCD and LCDC to get through a rulemaking on this, that's not going to be something that resonates with him or the county, frankly.
I wanted to call on Jan. I also saw that testimony would be accepted, and I didn't necessarily hear that there was testimony. So I don't know, Jan, if that's what you're.
Chair, sorry, this is Director Bateman off camera in the same room as Jan. The testimony is the invited testimony, which we just had. So that's completed. No public testimony on this item.
Right.
And I was just looking at the clock. I wanted to direct back to you, Madam Chair, to go into deliberation.
Thank you for that. I was like sitting here enjoying all this back and forth. Okay, so we'll move into deliberation and then hopefully to vote on this issue of whether to authorize the department to appeal this decision from Clackamas County to LUBA. Any initial comments from commissioners on this topic area and direction or thoughts of where you might want to be going? Commissioner Boyer.
So I haven't asked any questions because my fellow commissioners have asked them all for me. So thank you. I mean, clearly, again, it's all about what the rule means and, how it functions. So that's kind of where I'm leaning is that we need a better, definition of what the rule means to LUBA, and I'd like to hear what they have to say and the function of it.
Other commissioners? Vice Chair Lilac.
Thank you, Chair. A great discussion, really, really great discussion in all regards. I will support proceeding and supporting staff based on factors A and B, which to me are clearly stated in the county's letter from the county's attorney to us on this. And to me, that's kind of for lack of a better term, the tiebreaker is when the county says on page 3 of their letter, very specifically, the county agrees with the LCD. Anyway, it says it right there that the county agrees with A and B. They do agree there's a better path and a better approach, but to me, I'm looking at the factors that we're making a decision on, and they're just for us to consider. I don't know if we're compelled by it or not, but to me, that's the deciding point for me is to rely on the county attorney's letter on this. Thank you.
Commissioner Lazo.
Thank you, Chair. And actually, I would, Commissioner Lilac said almost exactly what I would say. And I think the thing that's difficult for us when this gets brought before us is, as we've noted before, the bar is very low. I think that, as Commissioner Lilac said, The county has also affirmed that the questions A and B need to be answered. I agree. I actually think in the motion that question E is actually not a question. This isn't a question about how those resources should be used in the county. This is a question about how that particular rule should be applied. And so I'm not sure we need E in there. It also does point out to us, I think it is unfortunate that the applicant is to some degree caught in this, and particularly not only the individual applicant, but at a time when we're asking the counties, frankly, what their role in Goal 10 is. We recognize that they don't have a role in Goal 10 now, but we are actually in rulemaking right now about what the role of counties in Goal 10 is. It's, things happen in parallel. We have to make rules while we're also doing work, and to some degree, these are the kinds of things that are the byproduct of that. So I think we need to get this question answered. I think there's the potential it could be a different way, but I think the question before us is answered and moves forward on my part under A and B.
Thank you. I don't know if Commissioner Thompson.
Oh, I do, Madam Chair. Thank you. I'm troubled by the fact that we absolutely need to have more housing. And here seems to be a really reasonable project, and yet our rule doesn't support it. And looking for the most effective, efficient, fairest way to resolve this. And given those concerns, I still trust the wisdom of my colleagues, and will, I don't want to say reluctantly, just with some sadness, go forward with supporting my colleagues in moving this forward to LUBA.
And I think I'm the last person to talk here. I mean, part of our challenge, struggle, opportunity, all the things that we do at the state are really this balance between conservation and development, the two terms in our title, and also existing within a framework which includes these appeal factors and analysis that are presented before us. So I'm, as very pro housing person as it comes, but also very pro thinking about the other values of our land use system. And so I think all the things that were said to date really kept on coming back to a legal interpretation issue between a case that happened that the department's saying is very specific and the petitioner saying is more broad, right? Specific to the circumstances of that case. And so it just kept on coming back to me like, this is a legal matter that LUBA has to decide versus kind of like an application and the rules part of it. And so looking at those appeal factors, which really are our calling in our role on the LCDC, it seemed very obvious that A and B were met in that case. I might also agree with Commissioner Lazo that E, is it absolutely necessary or not? I don't know to this case, but the A and B was very clear. So I am also of the opinion that this should move forward, and it just makes, in a totally different note that's not related to this exact necessary case, it makes me think about the processes and the capacity of the department to go after each thing that we don't agree with, and like when to move on an action and when not to. So to me, that might be like a resourcing thing, or I don't know what we would call that thing, but if I was happy to hear that the department objected to those previous ones versus if we affirmed like, yeah, that sounds cool, and then suddenly had a problem. But yeah, so I think that's the larger question that I'm left with for the future is, and there was a lot of talk about enforcement, which didn't really seem like the topic of the conversation from the department side. So I just wanted to say that. So with that, I was thinking about, does anybody want to make a motion? Or does anyone want to continue talking? It's up to us. Commissioner Boyer.
Kelly, can you put the motion up on the screen? I don't have it anywhere in my packet that I'm finding. Please.
I don't know if you got the annotated, it's on page 3,
Oh, is it? All
at
right.
the bottom. Or page,
Okay.
if you have the printed one, page 4 of the printed one.
All right, are you guys ready for a motion? I move that the commission authorize the department to appeal the subject decision from Clackamas County to the Land Use Board of Appeals based on the information included in this report and associated demonstration that OAR 660-001-0230 subsection 3 A, B, and E apply.
Any second to that motion?
Chair, may I make a friendly amendment to remove E from the motion?
And we can remove that. Any discussion on removing E? And I just wanted to read what E is. E says whether the case advances the objectives of the agency's strategic plan. Says this appeal, this is from the staff report. This appeal advances objectives of the agency's strategic plan by helping them to ensure that rural residential areas are not subject to more intensive development levels than currently, and that significant residential development is directed to urban areas of the state. The strategic plan's focus area 4, which is promote healthy and equitable communities, has several objectives that further that goal. So basically, essentially reinforcing that the majority of density happens in urban growth boundaries. That's how I read it. And did we want to have any discussion on removing that as a criterion for LUBA to consider? Pros and cons. Commissioner Lazo?
As I said before, I support removing it, again, because again, I think we can send anything up to LUBA, but I think what we'd be saying by removing it is, that's not a question that we actually need decided in this case. Because we would be weighing goal 10 and goal 14 with whether or not it's better to build, I think the question isn't whether or not 10, 5, or 2 is better. The question is, what does the rule say about how you apply what Clackamas County has at this point? And so I think E asks a different question than we're asking LUBA to settle for us.
I support slashing E on my motion.
In that case, I will second the motion. Thank you.
Okay. The one that read the proposed motion, could you say about the E part?
I did. I said I would remove.
You said
I
it.
would
Okay,
remove
good.
E.
And you
I
seconded
would
it.
support
Got it.
removing E.
I promptly forgot who initiated. Okay, thank you. Jan, we would like to take a roll call with the proposed motion that removes that is essentially what's written, but removes E as an applicable criteria.
Commissioner Warren,
Nay.
Commissioner Boyer,
Aye.
Commissioner Lazo,
Aye.
Commissioner Thompson,
So we need 4 to pass this. We have 2 ayes and a nay. Is that correct? Okay. Nay.
Vice Chair Lilac,
Aye.
Chair Halova,
Aye. With that, it looks like there's 4. This motion passes. Okay, thank you. So thank you all those that spoke and testified on the invited testimony list. I think, as I mentioned, I think there's some more procedural budgeting questions we could have that we may decide to bring up at another time to talk about these types of issues in the future. With that, I'm going to find this real quick. We're going to begin agenda item number 8, which is the Farm and Forest Work Session with Hillary Foote, Farm and Forest Use Specialist, and Jim Johnson, Land Use and Water Planning Coordinator from the Oregon Department of Agriculture. And I was just going to make a side comment, which I don't know if side comments are allowed, but that's probably the most split decision I've ever had since I've been on commission. So I thought that was interesting. Okay, we're going to pass that on to agenda item 8. I think they're moving into place in person.
Good afternoon. We're here. So for those of you who haven't met me, I am Hillary Foote. I am the Farm and Forest Land Use Specialist for the Department of Land Conservation and Development. And the intent for the rest of the afternoon is to talk about the purpose, the history, and the regulatory framework of Oregon's zoning-based farm and forest conservation program. So this background and understanding is going to be really important for the commission as well as the general public, as we're anticipating that there are going to be a number of agenda items over the coming year that are going to revolve around the Farm and Forest Land Use Program. So here today we have a special guest. Jim Johnson is the Land Use Planning and Water Coordinator for the Oregon Department of Agriculture, and he actually also served in my role at one point in time. So it has been really great to have Jim as a resource and a collaborator actually over the past 4 years. So Jim's going to talk a little bit about agriculture in Oregon as context for why we have Goal 3. You know, what are we protecting and some of the issues on the ground in the agricultural community as they relate to the land use planning program. And then I'm going to talk about some key concepts in the history. And I'm going to go very quickly through a lot of these topics, about 45 minutes of content. But the intent here really is that's an informal conversation. And the purpose is to make sure all of your questions are answered on some of these topics. So we're going to balance trying to get through a lot of material in a short amount of time. And, you know, jumping in and making sure your questions are answered. So I'm going to keep an eye on raised hands and the chat as we go along, and do my best to make sure people are addressed. And Commissioner Boyer, I was just about to ask
Yeah,
you
Commissioner.
to say a few words.
Commissioner Boyer.
All right.
Commissioner Boyer's great idea.
Thank you. Yes, my great idea was a 3-hour work session, and we're going to try and get this done in 1 hour. So I do want my fellow commissioners to, as we go through this next hour, if you feel like we need another work session between our January meeting, just a little bit more briefing, because based on the working group's information, there's a lot of meaty topics that are going to come to us in January. And I don't know if we're going to be able to touch them all in 1 hour. So I just want to put that out there first. And, you know, based on my connections with rural Oregonians and agriculture communities, it's becoming more important and almost urgent to have clear definitions with all the exceptions happening on agricultural land right now. Although urban and housing work is really important work, the rural and the agricultural lands are needing attention right now. They're needing our attention. You know, grazing land, agricultural land is being taken over by many different purposes other than agriculture. So by looking at all these exceptions, we can help have better clarity. And the planners are asking for this. So this is going to be really, really important moving forward for all of us. And please don't hesitate to say you need another work session, because I'd be willing to have one. So thank you.
Great. Thank you very much, Commissioner Boyer. So we're going to start off with some comments and a presentation from Jim. If you want to bring that up now, Jan.
And anybody that knows me knows that some by my standpoints are a lot longer than some, but yeah. So hello again, I'm Jim Johnson. I'm the Land Use and Water Planning Coordinator for the Department of Agriculture. And as Hillary pointed out, before I came to ODA, I was a county planner for several years. Worked for the Columbia River Gorge Commission, developing the National Scenic Area Plan there, did the farm forest elements. And then I was actually DLCD's first farm and forest coordinator. Before that, there was somebody that did farm and somebody that did forest, but not somebody that did both. And so I was actually the first farm forest coordinator. So a lot of these things we're going to talk about actually kind of happened while I was at DLCD, and there's been so much change. Hillary's correct. We really need to dive into these things. So I'm going to do kind of an agricultural site and situation. I apologize to Nick. He's probably seen a lot of this before, but here we go. I'm going to discuss some key points with you right off the start that I'll try to cover in this. Agriculture is very important to the state's economy, and I'll flesh that out for you. Agriculture is incredibly diverse in Oregon, and I'll try to quantify that for you a bit. Diversity, whether it's in crops, production systems, farm size, whatever, is what really keeps Oregon agriculture resilient, and I'll talk a little bit about that.
Will you move the picture? Jan knows how to do it.
Yeah. So, and then Oregon is a leader in protecting agricultural land, as you well know, and I'll talk a little bit about that. That's a nice photo of Jefferson County agricultural land within the North Unit Irrigation District, Mount Jefferson there in the background. So let's talk about the diversity of production of Oregon agriculture. We produce over 225 different commodities in Oregon. I can only think of 3 or 4 states, if even that many, that produce more, and they tend to have subtropical climates. So we're very diverse. We can grow a lot of different crops, and it's really helped us in the long run. When one crop is down, another crop picks it up. Farmers don't tend to just grow one crop in Oregon. They grow several different crops. They protect their subsoil, and that diversity really helps them to be viable. It basically helps to create that stability that I was talking about. That diversity allows for one item to pick up for another. Most of Oregon's agricultural products are not federal commodity crops. We're not talking about Midwest corn, hogs, sorghum, wheat type of thing. We're talking about a lot of specialty crops, high value specialty crops, niche crops and like, and I'll talk a little bit more about that. And Oregon, as diverse as it is in crops and landscapes, it's also very, very diverse in the size of farms and the types of production methods that go on, the operational characteristics. And that can be a very vexing thing for planners to analyze the impacts to agriculture when there's so many different kinds of things going on. So here's Oregon's top crops. Greenhouse and nursery, other than maybe 2 or 3 years in my 40 years working in Oregon land use planning, whatever, has been at the top of the list. Cattle and calves once in a while punches up there, but for the most part, greenhouse and nursery has been at the top of the list. When you look at this list, a couple things that I wanted to point out. If you take cattle and calves, hay and milk, 3 things basically related to livestock, and put them together, as an industry, they are much larger than greenhouse and nursery. And that's really, really important when we're starting to talk about some of these issues with what is agricultural land. Rangeland is important to the cattle and calf industry. And not just for feeding, but for wintering and the like or whatever. There's a lot of these aspects of these so-called marginal lands that are important to the dairy industry. So it's really, really important to take things like that into account. When you look at those 3 related livestock things, it's over $1.8 billion just in livestock related industries alone. The other thing I wanted to point out here, and by the way, the pluses and the minuses show where that commodity was in the year before last. So some have moved up, some have moved down, but we have a new one in the list. Industrial hemp wasn't on the list until this year, for a couple of reasons. Number one, it's a new crop, but number 2, it wasn't federally recognized as a lawful crop until last year, so we had no real statistics about it. And as Nick will know, I spent a lot of time over in Deschutes County dealing with cannabis issues. It's been around for more than just a year or 2. It's been around for several years now, and in fact, next year, that I wouldn't be surprised if hemp's not even on the list next year. They've taken a big nosedive in terms of that. Farmers can kind of be their own worst enemies by overproducing and the like. And in this case, some people were making money, so everybody wanted to make money. And you know how that goes sometimes. Here's the top counties in Oregon. Marion is perennial. Marion is, I can't ever think of a time when Marion County wasn't the #1 ag county in the state. But the rest of the list really moves around. And for example, Morrow County, when I first started working for the Department of Agriculture, Morrow County wasn't even in the top 10. Now it's #2. And it goes to show you how things can change really fast with agriculture in terms of developing. And in the case of Morrow County, of course, they got water onto the ground, and irrigated agriculture changed everything over there. But when you look at this list, Morrow, Umatilla, Malheur, Klamath, these are not Willamette Valley counties. So agriculture is really important on the east side of the mountains as it is in the Willamette Valley. And in fact, a lot of times on the east side of mountains, agriculture is the only game in town, so it's doubly important to those communities over there. And Oregon leads the nation in the production of these crops, and probably a few more that I left out. But you can see on this list all the specialty types of crops that we grow here. And so it wasn't that long ago that hazelnuts wasn't on this list, and then the hazelnuts took off. We've got 80,000 new acres of hazelnuts, for example, in the state of Oregon just in the last 5 to 8 years. It's just amazing how that changed things. When I was a kid, Marion berries wasn't even on the list. They were just starting to come out, and of course now Oregon's the leader in a lot of the caneberry type production. And then just some specialty crops that a lot of people don't really think about, but you look at carrot seed, parsley seed, some of the seed crops. Oregon is very specialized in some of these things, and seed growers need to have special circumstances, not only in terms of soil and water and climate, but also being able to be isolated from other products that might cross-pollinate with them. And Oregon provides those. And Jefferson County, for example, grows all of the garlic seed that's used in California. So without Jefferson County, they wouldn't even be growing all that garlic down there. A lot of the carrot seed for California's carrot crops comes from Jefferson County. So just goes to show you some of these niche crops and how important they can be not only to the state, but to the country. So let's talk about the broader Oregon economic footprint that Oregon Ag provides. $33.3 billion to the state's economic footprint. 31.1 in terms of sales of goods and services. So the actual sales of the products and the services related to agriculture. So your implement dealers, that type of stuff. And not to mention the other things related to agriculture is very broad in terms of its infrastructure needs. Everybody likes to talk about the infrastructure that cities need. Well, agriculture has infrastructure needs also. And I'll talk more about that later as we get into the slides. Agriculture and its related services accounts for over 15% of the state's economy. That's, by the way, second only to electronics, by the way. So we're #2. Over 20% of the jobs, 1 out of 5 jobs in Oregon has some relationship to agriculture. And just the value of the product at the farm gate, so coming off the farm, no processed value, it's just the raw product, is over $5 billion. Oregon is an export state when it comes to agriculture, and this is very, very important. 75 to 80% of the production value of Oregon's agriculture leaves the state. 35 to 40% of that value, the state's value, leaves the country. So it's an international market. It's the largest export sector in Oregon in terms of volume. Port of Portland moves more volume in terms of agricultural production than anything else. Of course, that also includes agricultural products from out of state. They bring stuff down the Columbia River from Montana, wheat, for example, things like that. But agriculture is very, very important to the Port of Portland. So it's also important to an urban setting also.
Yes, and Jim,
Yeah.
just as it went away, maybe I can ask you a question. When you had the leaving the country part, was that of the whole entire number? Was that a percentage of the total number, or was that a percentage of the one that leaves the state?
So the ones that I had leading the country were individual commodities. We lead the country in production of hazelnuts, for example.
No, sorry, I was saying the percentage number that you said that leaves the country. Was that a percentage of the total value?
Leaves the country.
Let's get the slides back up here. I lost them.
It's okay.
30 to 40% of production leaves.
Oh, yeah, okay, so
The slide
that is
before this.
30 to 40% of the state's agricultural production value, not
Okay.
the country, so yeah.
Yeah,
So-
I didn't know, sorry, the clarity I was seeking was, I didn't know if that was a percentage of the percentage that leaves the state or a percentage of the whole.
Of the whole, so
Okay.
that would be percentage of the whole that leaves the state.
Okay. Thank
In
you.
fact, let's see here, let me get back to that. So this is 75 to 80% of the production value of all Oregon agriculture actually is sold out of the state. We produce way more than we need inside the state of Oregon.
Yep.
And 30 to 40% of the agricultural value actually leaves the country.
Okay.
It's not sold here, it's sold. And some of our biggest exports are basically the Asian Rim. We have South Korea is North Korea. South Korea is a big receiver of us. Japan, Singapore. We've got our marketing folks are dealing with Vietnam and Singapore now. You've got you basically got upper middle classes growing in those areas, and they're demanding some of the high value products like blueberries, for example, that we grow here in Oregon. We're the second largest export sector in the state in terms of value after electronics. And basically we account for 19% of the total state exports. This is very important coming up. 60% of the Port of Portland's total tonnage of exports. Bottom line, Oregon agriculture is traded sector agriculture. And I always bring this up because when I get into these discussions under Goal 9 about economic development and the like, the industrial folks like to talk about, well, we create traded sector. We bring new money into the state. Agriculture is traded sector economy also. Remember what I told you, 80% of the production leaves the state is bringing new money back into the state. It's not just recirculating it. So we are traded sector, not unlike a lot of the industrial uses that like to talk about building on agricultural land. So now let's talk about the land base a little bit. There's 17 million acres in the state in farm use, and this is 17 million acres in farm use as defined by the U.S. Census of Agriculture. And that basically says that anything that generates $1,000 or more is considered to be in farm use. So take that with a grain of salt, because there's actually only 15.5 million acres that are actually zoned as agricultural land under Goal 3 in the Oregon Planning Program. And of that, what am I hitting?
Pesky thing.
You guys are seeing these things. Okay. So, and then of that, I got a big fat finger, I'm sorry. 13.1 million acres received special farm value assessment as EFU. So 15.5 zone, but a subset of that is only 13.1 that actually are receiving farm value assessment as EFU land. So see what I'm getting at? There's a lot of non-farm uses out there that disqualify some lands for farm use. So the ag land base is getting smaller as I go down this list. Some important things to recognize here. All I'm doing is hitting this arrow here. Yeah, go right to there. Okay, let's talk about the soils now as part of the land base. 4.6 million acres of high value farmland in the state as defined under state law. 40% of that is in the Willamette Valley. About 3.5 million acres of those high value farmlands are located outside UGBs and zoned for agriculture. So that 4.6, actually only 3.4 are actually zoned for farm use, as agriculture. But remember, I'm talking about high value farmland soils. Remember, the definition of high value farmland involves a predominance test where you have to have the total contiguous acreage, and then to calculate if it's predominantly composed of those soils to be considered high value farmland. Nobody has calculated that statewide, let alone for any individual county. So I have to always talk about high value farmland soils. I just don't get it. Yeah, that's fine. Yeah, what I'm doing is hitting this button right here. It's going on. I'll just touch it.
Maybe you'd have to try to stay in the PowerPoint world.
DNG word.
Sure, fine.
I mean, it's just
When in doubt.
just a
Just
suggestion.
having a clicker, so okay, let's talk about irrigated agricultural land. Now, this is one of the infrastructure issues that I was talking about. Oh, let's back up to the soils real quick, please. One more. About 1.2 million acres of prime farmland. So prime is the best of the best. 78% of that is in the Willamette Valley, and nearly 20% of that is just in the 3 Portland metro counties. So the best soils are also where all the growth is occurring. I wanted to come back to this also, though. If you look at the pictures here, and they're covered by the photos right now, but there's 3 photos here. But this soils discussion I just had does not talk about rangeland, and I just wanted to mention that the value of rangeland is calculated by a totally different system than looking at prime or unique or class 1 through 8 soils that we're all used to. It's looked at a lot more at ecological units, and that's a whole nother discussion we'll have to have sometime. But that is another issue in terms of how you define farmland and what is farmland, and that is defining what is rangeland. And I'm sure that'll come up during this whole process. But it's a debate I have with a lot of people in terms of what I consider to be valuable rangeland versus what some people would say we should just be putting houses all over the top of. So I'd also like to remind everybody, remember the value of those cattle and cows, and when we're talking about rangeland and whether or not you think it's marginal land or not. Also, just real quickly, if you look at that lower photo there, you notice that is Milton Freewater Vineyards. Look at the rocks there. A lot of people would say if those vineyards weren't out there, that this would just be, terrible ground. You can't grow any crops there. This is high value vineyard ground. Those rocks actually heat the vines. The soil underneath them is conducive to root growth, but the rocks themselves basically increase the temperatures and allow those grapes to produce some very valuable wine grapes. And so not everything goes by just being prime farmland. There are a lot of unique issues out there that need to be taken into account also. So let's go to the next one. Irrigated agricultural land. Go ahead. Yeah. Over 1.6 million acres of irrigated land in Oregon. Next one, please. Irrigation really is important. It enables more diversity of crops that can be grown on any given property. What used to be wheatland, put water on it, now you're growing vegetables, for example. Next, please. 43% of all of Oregon's farms do some irrigation within their operation. They may not irrigate the whole operation, but they do some form of it. Next, please. Irrigated farms in Oregon produce 73% of the total value of the harvested crops. So you can see the value of irrigation to water to agriculture. And right here, I'm going to make one quick statement that Brenda's heard me say a million times, going back to her days of water resources. This is a real issue for me when I deal about land use planning, and that is a disconnect between Oregon land use planning policy and Oregon water planning policy. We really need to start to connect that much more. It doesn't make any sense to me to protect agricultural land in Oregon if you're not protecting agricultural water rights, for example. Okay, let's go to the next one. All right, this is a graph that I use a lot that shows loss of farmland, land and farms over time. And it's really telling to a lot of people that aren't in the land use world, but I'd love to put this in here. This goes back to the middle 50s, so after the war, where and then comes up to the most current census of agriculture, which is 2017. And you can see that steep drop and loss of agricultural land. And where that starts to level out a little bit is, it's hard to see there, but it's about 1974. And of course, the statewide planning program was adopted in 1973. So you can see the difference that the statewide planning program made in terms of lessening that drop in the curve and the like. However, even with that, we're still losing agricultural land. If you look at the time period between 1974, which is basically the adoption of the plan, to the 2017 census, we still lost over 2 million acres of farmland, about 12.5% of the total. And if you go from the 1980s, the early 1980s to 2017, and the 80s are important because that's when most of the comprehensive plans, if not all of them in the state, were acknowledged. So we're accepted and such. We lost 1.7 million acres of farmland since then, or about another 10% of our farmland. So we're doing a better job than we did before the planning program, but we still got issues, and we'll talk about some of those issues coming up. Next slide, please. I always show this because
Can I,
it's
so
very
can I ask a
telling.
quick question? Just because we're on
Sure.
that slide, I'm not going to remember.
Sure.
If you go back to the one slide, obviously this curve right here is scary, which is probably a passion for a bunch of us why we're here. What was the choice on the Y part of the graph to put the 15 million acres? Was there any reason why it's those? I'm just curious, those particular top and bottom part.
Well, the 21 million up at the top is how many acres there were in 54 versus the 15.9, which is in 2017. So it's just the two ends of the scale. So
okay, got it.
Yeah.
Thank you. And we don't have any more data till from 2017.
The 2022 census was just completed. It hasn't been published yet. I've been really pushing my friends at the USDA to give me the numbers. They always try to sneak them out to me, but I haven't been able to get them yet. So they usually publish a year or so or more after. So I'm just anxiously awaiting.
And one more question. Sorry, this is data is like kind of one of the most important pieces of data. This, you know how the curve kind of has little breaks in it?
Yeah.
What are those breaks attributed to? Where it kind of goes down and breaks and then kind of goes up and
yeah, there's a couple of things there. There was, for example, one of those breaks where actually the number went up. There was a time when the census, the definition of farm use changes once in a while in the Census of Agriculture. And there was a time before the current definition where Christmas trees weren't considered farm use by the Census of Agriculture. Well, it's one of the leading ag industries in the state of Oregon. They added it to the definition and all of a sudden the acreage went up, even though those trees had been there before anyways. In other situations, we had drought years where land happened to be, where that drought year corresponded with a census. So it had been within that 5-year period and land may have been taken out of production. And so the numbers dropped and then it might have went back up. But in most cases, these really relate to some growth spurts and some changes and the like, but it's a very complex, response to your question because it can be definitional, it can be what's going on the ground, it can be a climate thing, it could be a new government program that encouraged taking land out of production for conservation practices. And so you have to delve deeper into that. That's why I like to look at the general direction as opposed to the specifics of any given census.
Thank you.
You're welcome.
It'd be nice, on that chart in the future to put a little star about the Oregon land use program, like where that hit, because it's kind of a significant moment in that chart. As
I will do that. This is one of my most popular slides, and I've had it for years. And every time a new census comes out, I add it onto the tail end of it and keep working that. So I wanted you to look at this because one of the things that I use to measure the effectiveness of the Oregon planning program is land values. And if you look at the agricultural land value per acre of Oregon, it is pretty much, especially in the West Coast, but almost any place other than some of the desert states or whatever, the land value of an acre of agricultural land is much less than the surrounding states and the like. And people ask me why, and I just tell you point blank, in my opinion, it's because the speculative value of the land is less in Oregon than it is in other states. You're not going to, the other states, you look at Idaho, look at that 10% growth in the last since the last measurement, $3.70 per, whatever versus $3 in Oregon. Idaho, they're paying for speculative value to put subdivisions on those lands down the future, so they have to pay more to rent or to lease or to buy agricultural land, whereas in Oregon, that land stays a little flatter. However, look at the percentage there. Let's go to the next slide. And just like you look at the percentage for Oregon, it's increased 9%, even though the actual land value is still lower than the other states. That increase, and I'll talk about this a little bit more, and I'm sure Hillary will, is becoming more apparent due to speculative land values related to certain non-farm uses like energy development or speculative values next to urban growth boundaries about, hey, maybe we're going to go to the legislature and be able to supersede an urban growth boundary expansion here and be able to develop it. So speculative values are still an issue in Oregon. They're just not as big an issue as the surrounding states. And one of the speculative land values you'll hear about later on from both me and from Hillary and probably from a lot of farmers at your next meeting are short-term rentals. You try to acquire farmland in Hood River County, for example, it's almost impossible because of short-term rentals. Next slide, please. Oh, here we go. Oregon ag land values continue to increase. Average value is less than almost any other state with growth pressures, primarily due to less speculative value. But we are having more and more concerns about it in Oregon due to development of non-farm uses. Okay, let's move on to this next. Got to get moving here. So let's talk about some issues and trends real quickly. I mean, I could talk about the ground in Oregon agriculture forever, but I tried to weed out as much as I could to get through here. So let's go to the next thing, please. So impacts of development agriculture, agricultural lands. Here's some of the issues. Conversion, land and water. So it's not just about losing land base, it's also losing a water base. And it's not just about losing land in general, but also the quality of the land we're losing as it relates to either livestock or to crops. So it's, you know, it's not just that we're losing land, we're also losing quality land. And critical mass. A lot of people always talk about, well, we've lost X amount of acres and the like. Well, what does that loss do in terms of the critical mass of agriculture, in terms of supporting the businesses that agriculture needs, the infrastructure that agricultural needs? I talked to some of the farmers in the North Unit Irrigation District, for example, and they're worried about the gentrification of their district. Every time a non-farm dwelling is approved, that 20 acres is taken out. Not only is the land lost, but that's one less person paying to operate that irrigation district. And so the farmers that are left have to pay more each time to run that system, as opposed to maintaining the critical mass to support that. And that could be done with lots of other elements of infrastructure, but I like to use that one because it's a very on the ground real situation. Next, please. Ability to conduct farm and ranch operations. You'll hear a lot about the farm impacts test to come, but what is the impact of conversion of land, of non-farm development on those adjacent farmers and ranchers, and not just individually, but cumulatively? Next, please. And when I look at these issues, you'll hear a lot about the footprint. So what's actually happening on the subject land that's in question, and then what is happening of the shadow cast by that non-farm development on the surrounding farms and ranches, on the surrounding abilities to operate and the like. So you'll always hear me talk about the footprint and the shadow basically conversion of non-farm development. Next, please. And then, of course, cumulative impacts, and you're going to hear a lot about this. Oh, it's okay to approve a non-farm dwelling, but when you approve 15 non-farm dwellings, 3 commercial uses that have nothing to do with agriculture, a couple of rural residential subdivisions, what's the cumulative impact of all of that together, as opposed to just analyzing impacts on a case-by-case basis? Next, please. So let's talk about this issue. There's over 50 non-farm uses now allowed in the exclusive farm use zone. And this cartoon is old. It was back in 2000 or so in the Capitol Press, but it still gets the point across. Exclusive farm use versus all the other land uses. The exclusive farm use zone, when it originated, only had about 10 non-farm uses in it. Seems like every other legislative session, we're adding another non-farm use to the list. Super siting. I hear about this a lot from the ag community. Gee, we thought the planning program was in effect and was going to protect us, yet every legislative session, somebody's going to the legislature to expand an urban growth boundary or to approve a use, instead of going through the process like everybody else has to go through. So super siting is a real issue to the ag community. Definitions, you'll hear a lot about this. What is a home occupation? What is a commercial use in conjunction with farm use? What is a park? You wouldn't believe the things I've seen in my career that people are trying to get approved of as a park. Siting standards. You'd be surprised. We don't have a lot of siting standards associated with non-farm uses. If you approve a non-farm dwelling and the land's not farm use, but you don't have a standard that says, gee, you've got to be set back so much distance from adjacent agricultural operations, they can put that non-farm dwelling right next to an orchard, for example. So maybe we should be looking at siting standards also for certain land uses in the exclusive farm use zone. Specific land uses, I'll get into that in some other slides, but some of the key land uses that I hear an awful lot from the ag community. Compatibility, the farm impacts test, and Hillary will talk about that. But this really gets to what, dealing with the offsite impacts of a non-farm use or conversion of land uses and the like, and then cumulative impacts. And I could talk about cumulative impacts forever, but we'll go on to the next slide.
Can I ask a quick question? Sorry,
Sure.
I'm the one interrupting.
No, that's great. I'd rather do
Okay.
it now than.
Yeah, the last slide. Yeah, I love that little graphic that was done. In this case of exclusive farm use to these variety of things that are happening, is this, pretend this was a real place, right? Exactly, a real place. Would this one on the right still be considered in our loss of farmland? Would this one on the right still be considered farmland and not a part of the loss?
No, it would be considered part of the loss because the numbers I'm using are not based on zoning. They're the Census of Agriculture, and they're looking at actual use of land for farm use. So that loss could be urban growth, it could be non-farm development, it could be a lot of things. So,
okay,
yeah, good question.
Because there could be two different charts, like the one you showed
yeah.
before that says this is for the use, and there could be one that this is for the land, and it'd be interesting to see the difference between those two.
Yeah, if you look at Hillary's numbers on zone changes, for example, land that's been removed from exclusive farm use zones by either urban growth boundary expansions or zone changes, that's only a small part of the loss of farmland. A lot of it has to do with non-farm development.
Got it.
That still may be zoned DFU, but it's been authorized for non-farm development.
Got
so
it.
Let's talk about some of those. Some of the key ones that we hear a lot about at the Department of Agriculture from the farming community that farmers are concerned about: open space and recreational uses on farmland. It's not only a conversion issue, it's a compatibility issue. Had a lot of issues in the last few years about rails to trails right in the middle of agricultural land. Parks, of course. Agritourism, it sounds like it's ag-related, right? Well, a lot of it is using agriculture as an excuse to basically do a commercial recreational use. And I'm sure you're going to hear a lot about that. The thing about agritourism, there's a lot of terms like incidental and subordinate in the law and necessary to support that have not been very well defined except by the courts. You'll hear about that, but those terms need to be better developed and that's, the work group has some things to say about that. I won't dig into that. And then wetlands, wetlands is an example of a use in the exclusive farm use zone that is basically permitted outright, but in effect converts agricultural land. If you take ag land and put it back to wetlands, you're losing agricultural land, and I totally understand some of that might have been wetlands before, but what's really missing in a lot of the analysis of this, because it's a permitted use, is no consideration of the impacts of that wetland development on the surrounding farms and ranches. You put a wetland in next to dairies in Tillamook County, for example, what's going to be the implication of salinization of water that's under those adjacent farms now that it's been allowed to come in close to those farms? What's it going to do to drainage? What's it going to do to bringing encouraging wildlife to come onto those farms? I always remember a farmer telling me in a work group I was in one time, yeah, you guys develop the wetlands, that's the hotels for these birds, but the farmers are providing the restaurants. So those kind of issues are not taken into account when some of the certain sub 1 uses that are allowed in the exclusive farm use zone. Commercial uses in conjunction with farm use, what does in conjunction mean? There's a lot of case law about that, but a lot of the counties aren't aware of that. There's also some definitional needs there, but it really, if you read the legislative history about that, what the legislature was talking about were businesses that have a direct relationship and need for agriculture, a farm implement dealer, a fertilizer dealer, those types of things. But that's gotten way out of line. Same thing with home occupations. Hey, when I was a county planner, home occupations were supposed to be, gee, you're a lawyer and you want to have your office in your house, or you're a CPA and you want to have your office in the house, and so we approve a home occupation. Wedding venues are being approved as home occupations now. So that is a really big issue with the agricultural community. Energy facility siting. I could spend a whole day on this one. Let's go to the next slide. Because I'll talk a little bit more about that in a second. So here's the issues with energy facility siting. Real quick, and this won't be one that you'll hear about the work group because that's going to be covered separately, but I wanted to talk about this is a key important issue with agriculture right now. The loss of farmland, the footprint of a solar facility individually can be huge, and cumulatively it has been huge and will continue to be huge. We have a 1,600-acre proposal on high-value farmland now in the South Willamette Valley for a solar facility. This is not Eastern Oregon marginal land. This is high-value farmland. Jurisdiction, I'm going to tie this right into what I'm talking about. Jurisdiction, FSEC versus local. The Energy Facility Siting Council, when they're looking at a solar facility, if it involves high-value farmland, you've got to take an exceptions. Well, under the statewide exceptions process for counties, you have to look at alternative sites. You have a reasons exception. You have to look and see if there's other sites that would meet the same needs. That wouldn't involve it being on that farmland. FSEC doesn't have to look at alternatives. So the energy people are going jurisdiction hunting to be able to get lands that they don't have to look for alternatives. I'll just say this about agriculture versus other developments. Agriculture is not only land dependent, it's soil dependent. Solar facilities are land dependent, but they can stick those solar panels on the top of rock outcroppings. So there needs to be some more consideration in terms of alternatives and the like. And I think that the work group that'll be getting going on that will hear an awful lot about that. Farmers are really concerned about speculative land and rent values. You'll probably hear from a farmer from Hood River County next month about how they're having real issues finding labor housing in Hood River County because of the speculative values of land and people acquiring houses out in farmland for short-term rentals, for vacation rentals, as opposed to it being available for farm-related housing. Compatibility with area farm and ranch operations, that's the farm impacts test. What will the impact be on surrounding farming operations? This is one that I already touched bases on, but we really need to talk about more. When you lose agricultural land that happens to be irrigated, you're not only losing the agricultural land, you're losing that agricultural water right in most cases, because it's not being transferred to agriculture. It's either being just put back into play or being transferred to a non-farm use. And as tough as it is to find ag land nowadays, it's even tougher to find agricultural water rights, new agricultural water rights. We're allocated in this state. There's not a lot of water left for agriculture. So water rights protection is very, very important. Co-use. Hear a lot of things about agriculture coexisting with solar facilities and the like. Let me just say this. I've yet to see a solar facility where you can drive a combine with a 25-foot header through it. Yeah, you can graze sheep under solar panels. You can put pollinator habitat on there. But if that's prime farmland or high-value farmland, it's capable of doing so much more than just grazing sheep or pollinator habitat. They could be planting hazelnuts out there. They could be doing vegetable crops. They could be doing seed crops. They're not going to be able to do that with solar panels on there. And then cumulative impacts. You'll just keep hearing this more and more. Let's go to the next slide, please. Land use issues with dwellings. Next, please. Non-farm dwellings. Really, you're going to hear about the concerns about non-farm dwellings, conversion of land there, short-term rentals, so existing houses being converted to short-term rentals and not being available and increasing speculative value, replacement dwellings. Replacing a single-wide mobile home with a house like you see in this picture here is not what the policy was supposed to be about replacement dwellings. So taking a very small dwelling and then using the replacement standards for putting a McMansion out there is not what replacement dwellings were all about, but that's what's happening. And then farm dwellings, are they really farm dwellings? We've got some issues in terms of how the standards are going in terms of the $80,000 income tax. Remember, I pointed out that a high percentage of farms in this state gross over $100,000, and that's the largest footprint in this state. Yet our test is only $80,000 in high value farmland and $40,000 on other farming.
I wanted to
ADUs.
ADUs, ADUs is a big thing in terms of talking about rezoning and like. There really hasn't been that much impact yet. When I've been hearing, there hasn't been that much development of them, and also. There's a lot of concerns in certain parts of the state. Let's take, for example, the Umatilla Basin, where they've got concerns about groundwater depletion and pollution. You're going to double the number of dwellings by putting an ADU on every one of those things. What's going to be the carrying capacity issues there? But I haven't heard a lot about ADUs and impacts to farm use yet.
And then Vice Chair Lilac.
Thank you. I just have to share, I just have to leave here in a couple of minutes with family visiting from out of state. Jim, I can listen to you all night. And it's not because I'm uncomfortable, because it sounds like you're talking about my home. So you can be sure I will watch the rest of the presentation, but I'll need to leave in a couple of minutes here. Thank you.
Let's move quick. So, speculative land values, next, please. Next, please. Regulation of farm use and right to farm. Now, this gets more into my world than yours, but it does relate to land use. Farm use is defined in land use statute. Same definition is used in the right to farm statutes. We're seeing more and more pressure put on by non-farm land users to try to regulate how farmers farm. And we just had this example in the last legislative session with a regulation of confined animal feeding operations with poultry farms. Lynn County just last week or 2 weeks ago adopted a new standard that poultry farms have to be set back 1 mile from all surrounding structures. 1 mile. And that was due to people complaining about poultry farms in the last legislative session. I'll tell you, I probably get on average 2 calls a month about people complaining about dust, noise, odor, propane cannons and the like. And people are always trying to regulate, trying to get to the regulation on how farmers farm. That's why we have exclusive farm use zones. It's not just about the land and the water, but the ability to operate. And so when these non-farm uses want to site out into farmland, we need to take into account that farm use is basically a dirty, noisy business. I love to point out that agriculture, farm use is basically factories without walls, and you wouldn't put residential uses and some of these non-type uses in the middle of an industrial park, yet we're going to plop them right in the middle of agricultural land. Let's go to the next one. Urban growth boundaries, another big issue for the agricultural community. Most of the urban growth boundaries are 30 years old. They're starting to fill in, so we're going to see more and more proposals to expand. I remember that 70% of the value of Oregon agriculture is in the Willamette Valley, and that's where 70% of the people live. Issues that come up a lot, the 20-year land supply. It's not that it's a 20-year land supply is an issue, it's that every city has to plan for 20 years as opposed to regional planning for population growth. That's something we talk about a lot in the ag community. Coordinated population allocation, that's gotten better since PSU is now doing the population allocation. But what about regional growth allocation? Instead of saying 5 cities need to all grow, what about all those 5 cities in a region planning for growth for that region? And you may allocate, one city may get nothing, but another city gets it all, or you divide it up differently instead of every city getting an equal 20-year supply. That's what Metro does, and maybe we need to start looking at doing that more in more places around the state to protect agricultural land. Buffers on urban growth boundary edges. Goal 14 talks about this, but nobody implements it. What's the best land uses next to agricultural uses outside the urban growth boundary? It's not high density residential. We shouldn't be putting residential out there if we can put industrial, which is more compatible with agriculture, or some of the recreational uses or the like. So we need to be thinking about the land uses on the edge of urban growth boundaries, and also if there's going to be non-compatible uses, about buffer strips and the like on the edges with agriculture. Agricultural infrastructure, I won't spend much time there more, but water delivery, food processing, implement dealers, fertilizers, chemicals, that type of stuff. And then super siting, which I already talked about. Let's go to the next one, please. Quickly, some other key issues. We're almost to the end that agriculture is dealing with and related to its competitiveness. High cost of labor is a really big issue. It's really becoming a bigger problem. Oregon has some of the highest labor costs for agriculture in the country. Costs of other inputs, fuel, fertilizer, electricity, that's all but having problems for agriculture. Complex regulatory environment. Not necessarily a bad regulation, but just how complex it is in dealing with it. Farmers need more help there. And then labor housing shortage. And I've touched base on short-term rentals and some of the other things, but farm workers, aren't going to live in McMansions and high-end type residential development. Next slide, please. Some trends to consider when you're going through this. Again, my discussion on urban growth boundary expansions, they're going to continue to occur. Most of these urban areas are bound by some pretty good, high quality farmland. Next, please. Water supply. We're in drought a lot of times, or climate change and the like. People like to talk about drought and some of the issues as a disaster. I first met Brenda, I think, when I was on the drought council with her. And I'm still on the drought council. And now when we talk about disaster and drought, my first question is this really a disaster anymore? Or is this the new normal? And we need to start planning for that. Next, please. Local food. Local food has become a big demand in Oregon. And I'm seeing lands that are currently not zoned for farm use being put into farm use to meet that demand. I don't know if we're ever going to downzone some lands, but I can tell you, I can show you some lands up in the Portland metro area that are zoned for residential development that are high value, intensive agricultural areas supporting the local food scene. Next, please. New crops. We're getting new crops with climate change. We're getting new crops with innovative changes. I mean, just look at the cannabis industry and what came in. They're growing olives in Yamhill County. I can go on and on down the list, but we're getting new crops, so that's going to change our thinking on certain things, including water availability. Next, please. Let's final points for your consideration. Oregon agriculture is incredibly diverse. Agriculture is important to the state's economy. Agricultural land is not an undeveloped environment. It's working lands. Agriculture is land and soil dependent. Agricultural practices can be impacted by non-farm development, not just the land base, but their practices. And don't forget water. Thank you so much. Next slide just got my name. So
Thank you. Thank you, Jim, for this thorough overview. It was very good. I'm interested in so many things. I could have asked a lot of questions.
I know. I mean, I think it's really good to hear from somebody other than me, who the commission will hear meeting several times throughout the coming year. And so I think it's really great to hear a different perspective on the land use planning program from somebody who's spent many years participating in it.
And this won't be the last.
As well. You know, and I just want to highlight a couple of the key things that Jim said, that, you know, agriculture is an industry in Oregon. It is an important economic sector that sometimes get lost, and it is dynamic. There are new crops that are coming. It is, you know, adaptive to what's going on out in the markets, and farmers are innovative and they'll respond to changes in markets, changes in climates. It's a living, breathing industry. And most importantly, it is a robust, dynamic industry that is dependent on a land base, right? And that's what the Goal 3 program is all about. It's protecting that land base to support Oregon's agricultural industry. And not just for the economy, but also if you look at our agricultural land use policy, it talks about securing healthful food for the people of Oregon and for the nation. So there's nods to food security as well as food sovereignty for the state. So when we talk about the zoning-based farmland conservation program that is sort of implements statewide planning Goal 3, we need to keep all of this in mind that Jim just talked about. This is what we're protecting, right? And Jim touched on some of the challenges that farmers face, you know, not just in land use, but like all these other complicated regulatory structures. The Farm Bureau at one point in time had a great poster of somebody hunched over carrying a giant bag on their back filled with all the issues that farmers face and have to adapt to. And land use is just one of them. Land uses on sort of adjacent surrounding properties that are devoted or developed to farm uses that can impact a farmer's operation. We've got about 10 minutes left, so I just want to remind the commission that the biennial Farm and Forest report to the legislature contains a lot of detailed information on the regulatory structure of the program, right? So that was the report that I brought to commission last November. That might be worth taking a look at again before January. It's posted on our website. We can have Jan circulate the link to that, the 2020-2021 Farm and Forest Report, because that'll have explanations of very different kinds of dwellings and some of the uses that we'll probably be talking about over the next year, like home occupations, and commercial activities in conjunction with farm use as well. So with the last 10 minutes, does the commission have questions, particularly for Jim? No.
Commissioners? Anybody have any questions? Commissioner Boyer?
That was a lot. I mean, I've seen your presentations a lot, and it's tough to go through it that quick. It's a lot of information to absorb. But the takeaway is, agriculture is under threat, and just by having better definitions moving forward, which I think will be the role of this commission, will be really helpful.
I'm excited by just this presentation in general. I think I've told people this before, like there's very few things I knew, unfortunately, before moving to Oregon, I guess. One was the importance of our land use system nationally. I think the second one was the Trailblazers. I knew about them. And then the third was how valuable agricultural lands is in this Pacific North region, like internationally. Like I understood that before moving here. And this conversation or presentation intersects between the two of the three things that I knew before I moved here, which was the land use and then also the value. And I think for me, I just see like a lot of people who are not intimate with these things that you presented really see agricultural land as almost like scenic land versus economic development and national security. And that's kind of there's many other things that it is, but those are two of the things that I think about a lot for our future that specifically intersects with climate change. Those things are can't be understated, I guess. So I was happy to hear some of those points that lead to that same conclusion. I don't know if commissioners have any other.
So Madam Chair.
Yes, Commissioner Thompson.
Thank you, ma'am. Well, as you say, there's so much more to be said and considered, but I'm thinking of the competing priorities and how they impact farming when we talk about social justice and we talk about climate change. I think it's important to have the impact on farming, but farming's impact on them. So if we could continue to integrate and relate these competing priorities, it would just help me feel like I knew what I was doing more.
Yeah, that makes sense. I think that's Commissioner Boyer. That was your reason for having us have briefings was also for those that are not working in agricultural lands like Commissioner Boyer is, that we fully understand kind of the issues, and some of those issues have come before us in a more intensive way, like the solar siting in relation to agricultural land. And we've, at least as long as I've been here, we've touched on some of these topics, but not in the holistic way. And I definitely agree with Commissioner Boyer that the definitions concept seems to be reoccurring for clarity on all sides, I think has been important. So I'm excited to see where this goes. Any other commissioners?
Well, and one of my takeaways from the work group, which you'll hear more about in January, is the complexity is low, but the impacts are large on these issues. So keep that in mind. Don't be intimidated.
That might
Commissioner
be a good segue, but sorry.
Commissioner Lazo.
Oh, I was just going to it's interesting, Chair, when we think about the Venn diagram between you and I think the only one that overlapped in what you just said is the Trailblazers. So I didn't understand the importance of Oregon's land use system nationally, and also I've lived in Oregon almost my whole life, and I haven't understood the value of ag land, and particularly in the context of land use zoning. And I think one of the things that struck me about what Jim talked about today was that there's a sense that I have right now that actually the land use system isn't working to protect ag lands. and I think we got to be careful about our approach moving forward, that it may be just not definitions. There may be a fundamental issue about that balance. And maybe we need to make a very different statement and impact about that balance and that value, rather than just patching it with saying we haven't got these definitions right. Because what's happened over time, it sounds like, is it's been highly eroded, to use an ag term, right? Over time, and so maybe we need to figure out a more systemic issue to fix that, rather than just leaving the system the way it is and making small tweaks. That's kind of what I took away from that is there might be a bigger problem here than just fixing the definitions of those allowed uses in EFU lands. That we really sort of revise the way we plan for the value of ag land.
And I jump in here if it's okay with you, Chair.
Yes.
Yeah, Commissioner, I would totally agree with that, and you'll see that in the report that Hillary will come out with. We talked about some of those larger issues, and some of those issues will probably take a little more of an involved approach, some groundwork up front. And I'll just use one quick example. I mentioned about rangeland and how that gets to the bigger issue of definition, just what is and is not agricultural land. I definitely, because I deal with this every day, 7 days a week, it seems like sometimes. I'll definitely tell you there are some issues with some of the bigger questions of what should be protected and what shouldn't. But also, we just have some bigger policy areas as a state that it's the statewide planning program, not just as farmland, but that we need to take the next step. We're very good at planning development for development and I always talk about urban growth boundaries when I look at them, planned loss versus unplanned loss. Non-farm development to me is not unplanned loss. Urban growth boundaries are planned loss. But I'm starting to wonder about that even sometimes when we start to think about priorities, looking at farmland in Oregon as the quality is versus other places where growth could occur, regional allocation versus every city getting it. There are some bigger issues there that are policy issues that may be the next step that the land use planning program has to take someday. So.
Yeah, and I was going to say, for me, in that same regard, Commissioner Lazo, like the one thing I heard a long time ago, it's a little bit of a blanket statement, was, once you convert farmland to development, you can't get it back. The quality cannot be gotten back. And I think for people who are not involved in agriculture, especially maybe people who are involved with development, they're like, oh, there's a commercial building and we want to change it now, tear it down and create a housing building. You can swap between all these uses, I would say relatively easy, right? If you have the money, you can swap. But the idea that you can just be like, now let's make it agricultural back, let's revert back is you've lost a lot of the qualities that are needed specifically when the high valued soil part of it. And so I think that's one of the things that's always stuck with me very strongly. It's not just lose it and regain it with new policies. It's a totally different thing that you're regaining if you regain farmland. It's not the same. Would you agree? Would you agree, Jim? That's a blanketed totally statement. Yeah. Director Bateman.
Yeah, I was wondering if we could just hear from Hillary as to next steps, because I know we need more conversation around this. And so what will that look like?
For June, so in the next couple of weeks, actually, we will be posting a report that summarizes the conversations that we'd had with our technical working group that we convened over the fall. So remember back in July, we had a discussion about this effort that we've launched, the Farm and Forest Conservation Program Improvements Project. And the first phase of that was working with a technical working group to define issues with the Farm and Forest Conservation Program, mostly technical issues, which could be improved to result in more clarity, better implementation with the policy goals of statewide planning goals 3 and 4. So we discussed a lot of issues. We identified 75 of them. And the working group also offered some suggestions of, how those issues could be addressed. So that process and those results are going to be summarized in this report. And that will be published in the next couple of weeks, and we'll be taking in public comment on that as well. So in January, on the 26th, that report, we'll be reviewing that with the commission. Okay. And the intent is then to come back in April with a work plan based on sort of direction and guidance from the commission in January, and any additional public comment and feedback that we receive on the report after it's published or through the commission's agenda item process. Directly following this, I'll ask Jan to send out a copy of my slides so you can see at least the issues that we're wanting to focus on, and make sure that folks understand it. Again, the Farm and Forest report is going to be a good resource for that, and Jan can send out a link to that where it's posted as well. I think that's about it for
And
next
I was going to
steps.
say, sorry, Hillary, if you had a presentation that I didn't realize was to be presented.
That is
and
fine.
yeah,
As
sorry about that.
Commissioner Boyer mentioned, it's a lot to cover. There's some really complicated topics that are going to be coming up, like non-farm dwellings. It's one of the most complicated reviews that's out there. There's 9 different tests for non-farm dwellings, depending on where you are in the state. And there's, 3 components to it, including a cumulative impact analysis. So
Yeah.
understanding how that works.
Yeah. So if you had a presentation to make that we weren't able to get to today, what would be the best way to get that present? Because I think we're going to have to hear it from you. I don't think reading through it is going to work.
We're good, but.
So can I ask a question quickly first? So Hillary, how much time do you need for your presentation and with questions? How much time would you want?
I think we're going to have a lot of public comment on that agenda item. In July, I think we had 40 minutes of public comments. We had 13 comments.
Sorry, I was a little confused. I thought there was a
How much
presentation
would you
maybe
need to do this today?
Oh,
Yeah.
today?
Yeah.
This is about 45 minutes of me talking.
Oh, yeah.
I mean, do you guys want to try and have a meeting before our next, like an hour and 15 minutes, just to hear from Hillary?
I could do it.
We
An hour would be
An hour,
best for me.
yeah, I like that idea. An hour would go quick, but I think the information is going to be valuable.
Madam Chair,
Yes.
we have a couple of things going on at the department. We'll need to do this as part of our January meeting.
Okay.
But
I just want to acknowledge that I didn't realize
Yeah, no.
that you had a whole presentation. Sorry about that.
But this is an ongoing presentation. I would propose that we might want to keep standing, well, maybe not every time, but a standing spot on the commission's agenda to continue to take chapters of this and address the conversation and next steps into the future. So I wouldn't say it has to be everything in January either. We've got time, and we've got the ability to keep this conversation going.
Okay. Commissioner Boyer, you good?
No.
I can see on your face.
Sorry.
Okay, we'll talk about it at our weekly meeting that we have internally. So we'll see what we can do. We've never had a moment where we like tape something and then people at their leisure could watch it. I mean, that's never been a thing that we've done, but I'm not gonna say we make a decision now, but that is an idea that I'm having as a potential in-between thing. Okay, I think we're at our time. So if we're all okay, I wanted to say thank you for joining us, unless there was any other thing, Director Bateman. Okay. Our next commission meeting is scheduled for January 24th through the 26th, 2024. I'm gonna have to get used to saying that, at the Mill Casino in North Bend, Oregon. And so with that, the meeting is adjourned at 5:02 p.m.